Buckle in, because what you're about to witness is one of the wildest sentencing hearings we've covered in a long time. This case has everything: contradictory statements, emotional pleas, legal confusion, and a judge who is absolutely done playing games. At the center of it all is Denzel Lewis, a man already carrying the weight of burglary convictions, revocations, and now a felony gun charge that could put him away for up to 6 years. What makes this hearing so explosive is the collision between the defense's narrative that Lewis deserves another chance, and the state's argument that he's already burned everyone he's been given. And just when you think it's straightforward, the judge throws a massive curveball. Lewis pled guilty, but now claims he didn't actually know the gun was in the car. That's a legal red flag the size of Texas, and the judge calls him out immediately. And the chaos doesn't end there. Jail conduct reports, disrespect to officers, allegations of indecent behavior. Lewis denies nearly all of it, but the judge has receipts. Multiple receipts, across multiple dates, from multiple officers. Stay locked in, because as this hearing unfolds, you'll see the judge piece together a pattern of behavior, challenge the defense, confront Lewis directly, and ultimately hand down a sentence that hits hard. And trust me, you'll want to tell us whether you think this ruling was fair or way too lenient.
Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears, with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor. And after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here.
Here's where things get legally fascinating. Notice how the defense is building a narrative around rehabilitation, family support, and the hope that Lewis finally understands the consequences of his actions. But right under that argument is a major legal tension. He pled guilty, yet still claims the gun wasn't his. In criminal law, especially with firearm possession by a felon, knowledge and control are key. If the gun truly belonged to his girlfriend and he didn't know it was there, that's a potential defense, or at least a reasonable doubt argument for a jury. But once you enter a guilty plea, you're telling the court, under oath, that you did commit the offense exactly as charged. This is why the judge is alarmed. You can't plead guilty for convenience. That undermines the integrity of the plea process. So, this moment right here is a huge turning point. Viewers, what would you have done in this situation? If you were the judge, would you accept a guilty plea from someone now insisting they didn't commit the offense? Or would you send the case to trial? Let us know.
from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track. He understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily, or are you pleading guilty because you did what they charged you with?
And I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So.
And now the prosecution fires back with a very different picture. A picture built on Lewis's past behavior and his conduct behind bars. Prosecutors love patterns, and here they're highlighting exactly that. Prior probation, revoked. Jail rules, repeatedly broken. Respect for authority? They say absolutely not. From their perspective, this isn't someone who thrives under supervision. This is someone who struggles with structure, boundaries, and compliance. Key elements for a successful probation candidate. This is where you can see the courtroom's emotional temperature rise. The defense is leaning hard on growth and support systems, but the prosecution is pointing to the real-time behavior that suggests Lewis isn't ready for second chances. And let's be honest, the judge is already showing signs of frustration. Audience question: does past behavior automatically predict someone's future? Should someone who struggled with probation before be denied the chance to try again? Let's hear your thoughts.
Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
Can I speak on that, Your Honor?
Sure.
The case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed off of my file, but it still shows up. That was not on me. It's somebody.
It's more than one time.
But
So hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis. I'm not, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers. It's not the same person saying the same thing about you. Somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds. Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around.
This is where the hearing takes a dramatic and honestly shocking turn. The judge begins reading through a series of jail incident reports, and these aren't small infractions. We're talking repeated accusations of disrespect, disobedience, and extremely inappropriate behavior toward officers. Multiple dates, multiple officers. Multiple warnings ignored. Lewis tries to push back, insisting these reports are false or misattributed, but the judge isn't buying it, not when the reports come from different staff members at different times. In court, credibility is everything. When your story clashes with multiple documented accounts, judges tend to trust the system over your explanation. This whole segment isn't just about rule breaking. It's about character, credibility, and respect for the court. And you can practically feel the judge's patience evaporating. What do you think? Do these infractions justify denying probation, or are they being blown out of proportion?
This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, I'm not doing anything, while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I don't know, sleep on my back.
Sir, we're really going to do that?
You ask me and I'm telling you, John, I sleep on my back. I have sisters, I have a mama. I don't do that. Them people write whatever
they're making this up on you. That's terrible of them to do that.
If you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time. I'm not on no restriction on none of that.
Okay.
Up in the county.
You were off parole, the way I do the math, less than a year. So you did your whole 8 years?
Yes, ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in SID.
For doing what?
Just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to a second-degree felony because of your history, and you're lucky you weren't. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Ms. Holmes. You can go with the bailiff.
And there it is. The judge hands down a 6-year prison sentence, sticking to the original plea cap, but making it clear that Lewis is extremely fortunate he wasn't enhanced to a higher degree felony. This outcome reflects several key legal realities. First, the importance of credibility when entering a plea. Second, how heavily courts weigh behavior, both past and present, when deciding probation eligibility. And third, the serious lifelong consequences that come with being a convicted felon in possession of a firearm. Lewis walked into this hearing hoping for probation, but his inconsistent statements, disciplinary history, and prior revocations all worked against him. In the eyes of the court, the risks outweighed the chances for success. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.